The objectives of this presentation are as follows. Provide guidance for MCEA proponents about consulting Aboriginal peoples and to improve the quality and effectiveness of Aboriginal consultation for Municipal Class EA. Proponents subject to the Environmental Assessment Act are required to consult with the entire community. Special effort must be made to consult in a meaningful way with Aboriginal communities potentially affected by or interested in a Class EA project. Proponents should identify those Aboriginal communities potentially affected by a project and determine the level of interest that the specific Aboriginal communities may have in the project. This presentation will assist with understanding definitions, identifying communities, effective consultation, duty to consult, documentation, resources, and frequently asked questions. Aboriginal people is a collective name for the original people of North America and their descendants. The Canadian Constitution recognizes three groups of Aboriginal peoples: First Nations, Métis, and Inuit. These are the three separate peoples with unique heritage, language, and cultural practices and spiritual beliefs. The definition of First Nations is a term that came into common usage in the 1970s to replace the word Indian. It has also been adopted by some First Nation communities to replace the term band. The word Métis is French for mixed blood. Historically, the term Métis applied to children of French fur traders and Cree women in the prairies, and English and Scottish traders and Dean women in the north. Today, the term is used broadly to describe people with mixed First Nations and European ancestry who identify themselves as Métis, distinct from Indian people, Inuit, or non-Aboriginal people. Many Canadians have mixed Aboriginal and non-Aboriginal ancestry, but not all identify themselves as Métis. Note that Métis organizations in Canada have differing criteria about who qualifies as a Métis person. Inuit are the Aboriginal people of Arctic Canada. Inuit live primarily in Nunavut, the Northwest Territories, and northern parts of Labrador and Quebec. They have traditionally lived above the tree line in the area bordered by the Mackenzie Delta in the west, the Labrador coast in the east, the southern point of Hudson Bay in the south, and the high Arctic islands in the north. Throughout this presentation, the Crown means the federal or provincial government. The federal or provincial governments are represented by various ministries depending upon the context of references. Aboriginal communities are located in urban, rural, and remote locations across Canada. They include First Nations or Indian bands, generally located on lands called reserves, Inuit communities located in Nunavut, Northwest Territories, Northern Quebec, Labrador, and Métis communities. Aboriginal rights can be defined as collective rights based on Aboriginal occupation and use of lands and customs, traditions, and practices that make Aboriginal societies distinctive. Aboriginal rights are protected by Section 35 of the Constitution Act of 1982. Treaty rights differ from the more general Aboriginal rights. Treaty rights are the rights that are included, either explicitly or implicitly, in a treaty entered into by one or more Aboriginal communities and the Crown. Examples of treaty rights include the creation of reserves or the rights of Aboriginal people to hunt, fish, and trap on Crown lands. Aboriginal communities commonly have interests that are in addition to the Aboriginal rights and treaty rights that may exist. The Environmental Assessment Act requires community consultation, which includes addressing Aboriginal interests. Aboriginal communities are expected to have a range of views to offer and contribute. Every Aboriginal community is different. Some communities are interested in the economic opportunities that a project can offer. Others have concerns with the potential impact of the project on their traditional uses of land, archaeology, cultural resources, and natural resources. Engagement may take on different forms in each community depending on both the scope of the project and the interests of the community. The common thread with respect to Aboriginal interests on municipal projects is the need for openness and early-stage inclusiveness. The previous slide used the word engagement in place of consultation. It is important to understand the difference between these two terms. Consultation is discussion with an Aboriginal community related to an Aboriginal right or a treaty right. Consultation is a legal term and should only be used when related to Aboriginal rights or treaty rights. Engagement is discussion with an Aboriginal community related to an Aboriginal interest. Although the same notice, meeting, or contact can serve as both consultation and engagement, the proponent must both consult and engage their Aboriginal communities. The proponent should always begin by determining which Aboriginal communities may have an interest in a project. Proponents are encouraged to contact the Ministry of Aboriginal Affairs, or MAA, and Aboriginal Affairs and Northern Development Canada, formerly INAC, to help identify which Aboriginal communities may have an interest in the project. At the outset of the project, forward these two ministries a project description and location with a map, and they will respond with a list of Aboriginal communities with interests in the geographic area. Additional research and engagement with the Aboriginal communities may uncover other communities with interests. Neither the MAA nor the AANDC should be sent MCEA project materials. MAA and INAC will only provide assistance to MCEA proponents in determining which Aboriginal communities may have an interest in their project. MAA and INAC are not review agencies and should not be sent project materials. The project proponent should always begin the consultation early and will remain involved in the consultation throughout the project. Key factors in defining the scope of the consultation program include the following: considering the scope of the project and potential impacts, and whether there is the potential for the project to impact an Aboriginal right or a treaty right. It is important to engage Aboriginal communities and provide meaningful opportunities for them to participate in the process. But it is also important to focus the consultation and not over-notify communities. Confirmation that a community wants to receive project information should be obtained where possible. If a community does not wish to receive project materials, they should be removed from the distribution list. The elements of consultation will vary depending on the project schedule, but generally will include requirements to provide notice of the undertaking to elected leadership, provide detailed notification early in the Class EA process, provide adequate time review and comment on potential impacts, provide the opportunity for face-to-face meetings and/or follow-up phone calls, consider and respond to any concerns and questions, and implement as appropriate any changes to the project in respect of concerns raised. Some possible considerations for the design and implementation of a participation program specific to Aboriginal communities may include the local language, physical and electronic accessibility of communities, governance structures, differing decision-making structures than found in provincial, federal, and municipal agencies, and potentially between individual Aboriginal communities themselves, consultation protocols established between federal, provincial, and municipal agencies and Aboriginal communities, relationships between Aboriginal communities, and the unique values, traditions, and interests of each Aboriginal community. In addition, it should be noted that the Aboriginal community may wish to work solely with federal or provincial governments, work directly with the proponent, and/or work with the federal or provincial government and proponents simultaneously. Proponents should give each Aboriginal community that may be interested a copy of all public notices. Ensure that the Aboriginal community is given the opportunity to participate in the planning and decision-making process, including consultation events. Undertake good faith efforts to engage Aboriginal communities, such as following up with telephone calls to ensure that the Aboriginal community is aware of the project. Discuss potential negative impacts of the project on any constitutionally protected Aboriginal or treaty right that may be identified and the measures to mitigate these negative impacts. Respond to concerns expressed by the Aboriginal community. Provide relevant project documentation and other information when requested. Have experts present technical content. Request involvement in developing monitoring plans, including seeking assistance in monitoring activities where appropriate. Request the Aboriginal community to advise the proponent in writing of the nature of any interests they may have in the project. It is important to consider the community's interests. Consultations are a two-way process. Proponents will educate the community on the project, and the community will educate the proponent about their interests, concerns, or rights. Aboriginal communities can have a range of interests and views to offer. Their knowledge and experience can add value to a project. Proponents conducting community visits should be flexible, responsive, sensitive, and prepared. A proponent's consultation may not be a community priority. Being sensitive to larger issues helps demonstrate good faith and build stronger relationships. It is also important to use appropriate communications techniques and tools. Most communities will be looking to see that proponents are interested in developing a relationship. Personal meetings can help build the relationship and demonstrate good faith. Take language preferences into account. Materials may need to be translated. Consider Aboriginal-run newspapers, community radio, websites, and other communication tools. Many of the activities related to MCEA involve environmental studies and environmental data collection. Aboriginal peoples have the potential to make important contributions in this area. Traditional knowledge can have particular value in understanding species, ecosystems, sustainable management, conservation, and wise use. Much of this knowledge may be orally transmitted, and it may be considered sacred. Therefore, it is important that Aboriginal traditional knowledge, as well as community attitudes and desires regarding the use of traditional knowledge, be treated with the utmost respect. Traditional knowledge should only be incorporated when a community has agreed that this information should be included. The nature of consultation required will vary with the strength of the claim and the severity of the potential impacts on the Aboriginal and treaty rights. Projects vary and the rights held by communities are diversive. Where adverse impacts are minimal or claims weak, the extent of information exchange that is required may be more limited. Where projects are more complex and adverse impacts more significant, more and differing effort may be required, including face-to-face meetings and ongoing dialogue, perhaps requiring accommodation of the rights and mitigation of any potential impacts. The Crown's duty to consult has its source in the honour of the Crown and the constitutional protection accorded Aboriginal rights and treaty rights under Section 35 of the 1982 Constitution Act. When does the Crown have a duty to consult Aboriginal peoples? The Crown's duty to consult can be triggered when a decision is being made by the Crown and when the Crown contemplates conduct that might adversely affect the right in question. Municipalities are creatures of the Crown, and municipal projects are considered Crown projects. Trigger occurs when there is a potential infringement of an Aboriginal or treaty right. For MCEA projects, the Crown's duty to consult can be triggered even if a Part 2 order is not requested. Triggering the Crown's duty to consult depends upon the impacts the project may have on an Aboriginal or treaty right. The duty to consult is not triggered when a project impacts an Aboriginal interest. While the proponent is engaging their Aboriginal communities, if the proponent learns that a project may adversely affect an Aboriginal or treaty right, the proponent is required to notify the Director of the Environmental Assessment and Approvals Branch. Notification should occur as early as possible as soon as the proponent learns that a proposed project may impact an Aboriginal or treaty right. When required, the Ministry will review the proponent's MCEA project information and determine if the Crown has a duty to consult with an Aboriginal community. Consultation with the Aboriginal community may then be carried out by the Ministry of Environment as may be appropriate. It is important to note that project proponents will still be required to undertake some procedural aspects of the duty to consult. What is the content of the Crown's duty to consult? The content of the Crown's duty to consult is determined on a case-by-case basis. In recent court decisions, the Court identified the following considerations in the analysis of consultation content requirements: specificity of the treaty promises and/or claim, seriousness of the impact, and the history of dealings between the Crown and the First Nation. General public consultation is usually not sufficient, and the First Nations should be directly contacted and their input solicited. Proponents are often in the best position to discuss the project with Aboriginal communities. The Crown, as represented by the Ministry of the Environment, may therefore delegate the procedural aspects of consultation, such as explaining the project and its technical details, answering questions, assessing impacts, and proposing mitigation measures. The Director of the Environmental Approvals Branch will provide the proponent with specific guidance on fulfilling the duty to consult when required. Clear and concise records can help avoid misunderstandings and provide structure to progress on agreed-to plans. Proponents should thoroughly document the engagement and consultation process. Many Aboriginal communities consider traditional knowledge sacred. It is recommended that proponents discuss and respect communities' wishes regarding what information can be shared and how it can be used for the project. A consultation record should be prepared and made available to the Ministry upon request, and most likely in the event of a Part 2 order request. A consultation record should include a listing of which First Nation and Métis communities were identified as having a potential interest in the project, including a rationale, all notification activities, including dates and copies of all letters and follow-up phone calls to First Nation and Métis communities, a record of the type of information provided to the First Nation and Métis communities, concerns raised in correspondence from First Nation and Métis communities, including meeting summaries outlining the dates of face-to-face meetings, teleconferences, etc., who attended, the purpose of the meeting, what concerns, if any, were raised, and what was agreed to, how concerns raised by the First Nation and Métis communities were addressed, and a list of any changes to the project that were made as a result of the consultation. To assist with determining how to contact specific Aboriginal groups, for example, phone numbers, mailing addresses, and email addresses, and communities, the following information resources are available. The Chiefs of Ontario website provides a directory of contact information for all First Nations and Chiefs, as well as a map of the locations of Ontario First Nations. Natural Resources Canada maps showing all First Nation reserve lands are available for purchase on the NRC website. Natural Resources Canada online historical Indian treaties map showing historical First Nation treaties across Canada is available on the NRC website. The Aboriginal Canada portal has a list of all First Nations in Ontario with links to maps of individual communities. The Ontario Ministry of Aboriginal Affairs has a mandate to promote collaboration and coordination across ministries on Aboriginal policy and programs, set priorities for and track the progress of Ontario's Aboriginal agenda, enhance government's awareness of Aboriginal people, issues, and best practices for consulting and engaging with Aboriginal people, work with the federal government to find ways to make the most of federal funding, help Aboriginal people to access Ontario government programs, services, and information, reform the land claims process to help address historical grievances, and to encourage diversity, especially representation of Aboriginal people in the Ontario Public Service. More information can be found on the MAA website at www.aboriginalaffairs.gov.on.ca. Aboriginal Affairs and Northern Development Canada, formerly Indian and Northern Affairs Canada, supports Aboriginal people and Northerners in their effort to improve social well-being and economic prosperity, develop healthier, more sustainable communities, and to participate more fully in Canada's political, social, and economic development to benefit of all Canadians. More information can be found on the AANDC website. Contact INAC to obtain information about projects affecting reserves, which may require a land instrument from INAC, specific claims, comprehensive claims, federal litigation, and federal programs and services for Métis, non-status Indians, and urban Aboriginal people. Information regarding provincial contacts and resources can be found at the following websites. MOE local district offices have a First Nations liaison officer on staff that may be able to assist in this and other consultation and/or engagement steps. Aboriginal communities should be contacted through the Chief and Band Council. Métis communities should be contacted through the President of the local community council. Is Aboriginal engagement still required if there is no duty to consult? Consultation is required under the Environmental Assessment Act. Whether or not the Crown has a constitutional duty to consult, the Aboriginal community must be engaged, as they may be an interested person for the purposes of consultation during the preparation of an MCEA. When should Aboriginal consultation and engagement occur? Proponents should discuss their proposal with Aboriginal communities early in the process to determine whether the project may have an effect on them. Generally speaking, Aboriginal communities should be provided the opportunity to be consulted about an MCEA project at the key stages in the planning and decision-making process in which government agencies and interested persons are consulted. What is an asserted right? An asserted Aboriginal or treaty right is an Aboriginal right or treaty right that has been asserted by an Aboriginal community but has not yet been proven in court or included expressly in a treaty. If a proposed project has potential to impact an asserted right, contact MOE's Director of the Environmental Approval Branch for guidance. What if the community doesn't respond to notices or attempts by a municipality to consult? Ensure that the Aboriginal community is given the opportunity to participate in the consultation. Undertake good faith efforts to engage Aboriginal communities, such as following up with telephone calls to ensure that the Aboriginal community is aware of the project, and documenting attempts to contact Aboriginal communities in the EA documentation. No response does not mean no interest. Should Métis organizations be contacted? Yes, Métis are considered an Aboriginal people and should be contacted if potentially affected by the project. What happens if there is a funding request from a community to participate in the Class EA process? Although funding is unusual, MCEA proponents should consider on a case-by-case basis whether it is appropriate to accommodate funding requests made by Aboriginal communities that want to participate in the planning and decision-making process of an MCEA project. This could involve remuneration for travel and meal expenses, or in some cases, a more broad consideration of expenses. For example, capacity funding may be appropriate, where impacts to a known Aboriginal or treaty right are anticipated. What distinguishes between engagement and consultation? Engagement is interest-driven, while consultation is driven by potential impacts to Aboriginal and treaty rights.